Whoa. How the hell do you jump to that conclusion? You lied to me. You want me to play it back?
Judge, I certainly do not. But
you want me to play it back?
Judge, I certainly, if Your Honor some other time wants to, that's fine.
No, you want me to play it back. You're playing fast and loose with words. You need to file a written motion. How long is that going to take you?
Judge,
how long is that going to take you?
Judge, certainly.
How long is that going to take you? You're wasting my time.
This defense attorney walked into Judge Simpson's courtroom like he was about to change the law itself. He's arguing that the judge shouldn't even be on the case because he signed the original search warrant that produced the evidence. But that's completely legal. Every real attorney knows that. His argument feels less like strategy and more like desperation, just trying to stall or throw confusion into the mix. You can literally see the judge's patience wearing thin as this guy talks himself into a corner. Oh, and to top it off, he flat out lies to the judge's face. Let me know in the comments if you think this lawyer might be running on something that rhymes with propane. Let's get into it.
On behalf of Darren Dwayne Wilson, sir, please stand and give your full complete name for the record.
Thank you.
Judge, if I may, very briefly.
Well,
thank you, Judge. And certainly, Judge, I got much respect for this honorable court, been before this court a number of times. Judge, but the court rule is clear, Judge, that an examination must be conducted by a neutral or detached magistrate, Judge. In this particular case, and just for a little bit of context, for Your Honor, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identifies a mixed race, ethnicity, light-skinned male, certainly not my client who's got brown skin with girl hole. Judge, notwithstanding saying, Your Honor did the sole basis that the people intend to introduce quote-unquote identity is through the search warrants and the subsequent evidence that was purportedly obtained thereafter, Judge. I say that all to say that, Judge.
I don't know what case you're talking about. Who's the co-defendant?
You didn't preside over that. I could make the argument a lot more.
I did not preside over it?
No. So the argument that sounds like TAUNT.
Well, I'll let him finish, because I don't know, he did not even begin to ring a bell.
But if I can just streamline it, Judge. In brief, Your Honor was presented ex parte with 2 search warrants in this particular case. Ultimately, these 2 search warrants, there was information heard, there was a search warrant, there was probable cause found, there was search warrant signed. Judge, we now come before you for a separate analysis of whether there's probable cause in this case, but Your Honor, pursuant to People v. Real, which is 391-124, Judge, it certainly cannot be neutral and detached when Your Honor respectfully has already found probable cause in this case, and specifically the case law says.
Whoa. How the heck do you jump to that conclusion? Because the probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant. That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion. But I'll let you continue because I think it's a... Go ahead.
Thank you, Judge. And Judge, just certainly to preserve the record, certainly I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says that the defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor signed both of the search warrants in this particular matter. Certainly testified.
But that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your position...
Does that case clearly apply to search warrants?
It's not limited to search warrants.
But that isn't what I asked you, Mr. Martel.
Yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I have heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case applied to something that I don't think that applies to.
Judge, what I'm
Just by the very words that you said. And certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then hear the preliminary examination where they made a finding.
Judge, specifically this relates to an arrest warrant, not a search warrant. However, if it's the position of the court that Your Honor has heard no testimony, sworn testimony or otherwise, then I guess our request would be moved. But
I have read, so that we're clear, because you're playing fast and loose with words. So that it's clear, I would have read the search warrant. I would not, don't recall receiving any testimony at all regarding that search warrant, so typically don't. I make a determination if there's probable cause contained within the four corners of that document, swear the individual in, sign off on the search. It's really as simple as that. So if you show me a case, Mr. Martel, that says under those circumstances the court should be hearing, then show me the case. Otherwise, you're wasting my time.
For now, this attorney is really reaching, claiming that Judge Simpson is biased just because he signed the original search warrant. His argument, that since the judge already found probable cause once, he can't possibly be neutral now. But Judge Simpson shuts that down instantly, explaining that he didn't hear witnesses or make any rulings. He simply reviewed an affidavit and approved it, which is exactly how warrants work. It's standard procedure, not bias. This defense attorney is clearly trying to sound sharp, but comes off like a first-year law student bluffing his way through finals. Honestly, he's doing his client no favors here, and the longer he talks, the clearer it is that the judge is done entertaining the nonsense. If you think this lawyer's living in his own reality, hit that like button. I want to see how many of you are thinking straight.
Judge, so acknowledge, I would say that Burrell is applicable, and I would also humbly submit, Judge, to the position of the court that anything outside the four corners of the exam transcript has been analyzed or sworn to, then it would certainly fall.
Then you're going to need to file a motion. So I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. You need to file a written motion. How long is that going to take you?
Judge,
How long is that going to take you?
Judge, certainly it is.
How long is that going to take you? If you cannot answer that question, then I will take a recess. I will give you time to think about that, and then I will come back and I need your time frame for how soon you can file the motion. In fact, why don't we just do
We're
that?
prepared to proceed.
Why don't we just do that? You can take him back. Court's going to stand in recess.
And good afternoon once again, Your Honor. Good afternoon to your fine staff. Please, the Honorable Court, Edward Martel, P85051, on behalf of Darren Dwayne. Once again, for the record.
Have a seat. So, Mr. Martel, you know, I'm a bit concerned. I just take what people give me. But I'm just going to say this. You lied to me at the very beginning of your argument. I went back, had my staff go back. You said that I held a preliminary examination on the co-defendant. I couldn't recall it, but it's not true. That was an absolute falsehood and misrepresentation to this court. Ms. Hughes then points that out, but I'm still not sure. On the break, I go back, have my staff look it up, which was some doing, but the case that you're referring to as a co-defendant is Christopher Harrison. I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding refusal started with and I hate using the word, but it's true, it started with a lie. Then, Mr. Martel, you continued with your lie regarding the import of the case of People versus Burrell. You cite one portion of it about a magistrate who takes testimony and does that, and that's why I went through exactly what this court does regarding search warrants. And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. And I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't, we can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different, preside at a preliminary examination.
If I may?
If it be a lie, go for it.
Judge, respectfully,
No, you lied to me.
okay, if I may, Judge, very briefly, I think the record will reflect it. When I cited or spoke about a preliminary examination, I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that for context.
You want me to play it back?
Judge, I certainly do not. But
You want me to play it back?
Judge, I certainly, if Your Honor, some other time wants to, that's fine.
No, if you're gonna sit up here and tell me you didn't lie to me, you want me to play it back?
Judge, then I stand corrected, Judge, but I certainly intend to make no misrepresentations of the context. The main argument is what it is. And certainly, Your Honor is not barred from presiding over this exam. But again, and I spoke with my client in the basis of just preserving the record and putting forth this argument, certainly mean no disrespect, harassment, or delay to the people. Judge, we're prepared to proceed. If Your Honor intends to deny, that's fine. Again, we're prepared.
I don't know what your motion is, because everything that is presented to me is not it.
This guy just won't quit, and somehow it keeps getting worse. He's nitpicking random legal terms that don't even apply, clearly trying to get the case moved to another courtroom. I don't know if he's got personal beef with Judge Simpson or what, but the hostility is written all over his body language. From the moment he walked in, pointing and waving his hands around, you could feel the tension rise with every word. Honestly, I feel bad for the defendant. Imagine sitting there watching your own lawyer self-destruct and drag your case down with him. Judge Simpson would be well within his rights to hold this guy in contempt, especially after that blatant lie. I've seen lawyers push the limits before, but this one is flat out reckless. He's not defending his client. He's just gambling with the court's patience. If you think this attorney's making things worse on purpose, let me know in the comments. But buckle up, we're not done yet.
Anything else, Mr.
Judge,
Martel?
very briefly, and I'm certainly
Because I'm gonna tell you that, quite frankly, Mr. Martel, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recused for the purpose of forum shopping.
Absolutely.
Because, I think so. Because originally I had to step into this case, and I can tell you, you probably weren't necessarily real excited about it. But that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think, to try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor, and I certainly had no interest on the fact of the exam or the transcript thereafter. As far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth the position of the court that it's not certainly, Your Honor. We will move forward with your denial, and we're prepared.
I have not ruled. You will hear my ruling loud and clear. But do not presume that I'm going to deny it. Before I stepped off the bench, I asked, and I think properly so, your motion should be in writing. How long will that take you to do? If you won't answer me, then I will set the time.
2 weeks, please, and thank you, Judge.
Defendant's motion to recuse would need to be filed by December 10th. Prosecutor will respond by December 20th. I will hear the motion on December 26th. This exam is moved to December 26, 2024 at 12 noon.
Thank you, Judge.
This hearing was on a whole different level. Usually, it's the defendants who dig themselves into a hole. But this time, the defense attorney managed to outdo them all for all the wrong reasons. He could have kept it clean, focused on the evidence, and wrapped things up smoothly. But no, he decided to push Judge Simpson's patience to its absolute limit, and that's never a good idea. Honestly, I wouldn't be surprised if his client had a few words for him after this disaster. It's crazy how often lawyers end up being their own client's biggest problem in court. And like I said earlier, whatever this guy was running on, it definitely rhymed with propane. I'm not making any wild claims, but something was definitely off. Let me know in the comments if you agree. Thanks for watching, guys. Be sure to like and subscribe. If this one gets enough love, I'll drop a follow-up soon.